Welcome to Books for Beneficiaries. My name is Pete Williams, the host of the program on which we talk about the needs of beneficiaries. In estate planning matters, it is the estate owner that takes center stage, and that, of course, is appropriate. It is, after all, their wealth. However, the beneficiary sometimes is left in the dark as to the process. They have needs and questions. They want to ensure that they have their proper inheritance. So I am hopeful that this series will shed some light and give them some information that will help them. I call this series Books for Beneficiaries. So stay tuned for the next chapter and check back for more to come. Hello and welcome to the program. My name is Pete Williams. Today we're going to continue a discussion about the probate process. We had talked about probate in definitional terms about what is it, and how did I get here. I want to start introducing what goes on in the process. What are these notices? Why are these certain people involved? Those are the types of questions I want to answer in the next couple of episodes. So let's just step back a little bit and talk about the big picture. You know, the idea of probate is to gather up these, what we call the probate estate. From last time, we learned that when someone dies, not everything has to be probated, if anything at all. But we gather up those assets that are generally in the name of the decedent only and not in some beneficiary designated asset category. And we put those assets through probate, and we do an inventory of those assets. We identify debts and we pay taxes in a probate process. And then whatever's left over, we transfer to beneficiaries. So what do we do? You know, step number one is to assess. When somebody dies, the first thing to do is to start looking for documentation. It may be a will, it may be a trust. Once you find documents, you want to look at assets and find out if there's a need for probate. Probate only concerns itself with what's called the probate estate. It does not handle assets that are in some form of beneficiary designation, such as IRA beneficiary, pay on death account, joint tenancy arrangement, assets in a revocable living trust, if it's executed properly, are not probated. And then you want to review debts. You know, you get statements. And then, of course, in this whole beginning phase, you want to contact advisors. And that includes legal advisors, attorneys, tax advisors, if somebody had an accountant, and financial advisors. We want to find that last will and testament. And that last is emphasized. Somebody can execute a will and then later on revoke it and start a new will. So if the new will is properly done and revokes prior wills, which normally that's what a new will does, old wills are no longer valid. So if you're a beneficiary in one of those old wills, it is of no value to you unless you're trying to say the new will, it was under undue influence, or the person didn't have mental capacity. That can be important, but the last will and testament controls. When there is no will, we call it intestate succession, and there's a certain inheritance family tree that is devised to pass on assets. Now, what is very common today is that settlors create a living trust to put assets in, and by design, they're trying to avoid the probate process. They also normally create what's called a pour-over will. Once a trust is created, settlor transfers assets to trust, and then it's those assets that avoid probate. So just in case there's assets left outside the trust upon death, a pour-over will says, hey, look, if I die and I didn't get around to putting assets in my trust, pour them into the trust and have the trust control. Now, that may still have to be probated to get those assets into trust if they were a certain size and a certain character. So who's in charge? Now, again, we're talking about probate. We've got our other assets that may avoid probate, such as a living trust, and there's a trustee in charge of trust assets. Who's in charge of the assets under probate? And that is normally the person named in the will, who's called an executor. And then what you want to do is find out if the person who's named in the will is willing to act as executor. The person may be deceased. You may be the person. So if you are, that's fine. If there's no will, then someone is asked to act as a administrator. And then once a person is identified who's going to handle all this, whether it be an executor or administrator, then there's a petition filed. And what happens is there are letters which give authority to the executor administrator. So here's a section out of the Uniform Probate Code. It just says to acquire the powers and undertake the duties and liabilities of a personal representative, that's executor or administrator. A person must be appointed by order of the court. So you have to file a petition. The petition is actually asking for a few things, but the most important things are initially, hey, is this the last will and testament? And number two, this is the person who's going to be in charge. And that petition goes out. It's given to everybody that the person in charge knows about, spouse, children, heirs. You just really want to give notice to the world. And you even, ultimately, you file notice in the publication. What you want to happen, whether you're executor or not, but what you want to happen is that everybody has a chance to go into court and make objections to the probate process or confirm what's going on in the probate process. You do not want to skip the rules here for two reasons. One is later on in the process, somebody finds out that they weren't given notice and they should have been given notice. The executor is going to be in trouble and the whole process is going to be turned upside down. Secondly, most wills and trusts, for that matter, have something called the no contest clause. That no contest clause in a will or trust says that if you are involved in trying to do something other than what the decedent wanted, you could be completely disinherited. There are also people that request notices. So once again, you've got this system in place where in most counties, in most states of the United States, have notices of death. And believe me, your credit card company, any lenders out there, watch those notices like a hawk. They know when somebody died. So they will know about a death. So if you haven't given them notice, they will know and they will contact the court saying, hey, we want to have notice about this matter. Most petitions that are handled go unopposed. And if they do go unopposed, the probate judge will order up a probate. The court on its own may see something that's a little bit lacking in the paperwork and then ask for the petitioner to come back and prove something up. If there's evidence needed to prove up a will, and that is an interesting common fact pattern because most of the time when we execute estate planning documents, we name people of our own age, typically. So by the time we get old and die, our named executor or our named trustees have died. So proving up a will often requires one of the witnesses to come forward and say that they signed the will on that day. And sometimes it's difficult to find because they're either deceased or they've moved on. Who are the beneficiaries? Well, again, this could take us a million different directions. But for one thing, I want to mention that child or children normally means adopted children. We talked last time about inheriting per stirpes, where if a child dies before a parent, then it's that child's children, the grandchildren, that inherit that share. So the drafter of the will, the testator, should be very specific as to all contingencies. So what do you mean by beneficiaries? What do you mean by my children? Here's another example, just real quick. And again, there's thousands of examples out there, but let's just say that mom writes a will and says, I give all of my assets to my children in equal share, or to their children if they die before me. But you know what? I give nothing to my no good son, Billy, who doesn't deserve a dime. Now, let's just say Billy dies before mom does. who are the beneficiaries in that situation? Is it to the surviving children? She said, I give my assets to my children in equal share. But she also said to any of their children, the grandchildren, if a child dies before. But she also said nothing to Billy. Do the grandchildren, are they disinherited by virtue of their father's disinheritance, or are they included because it was not specific? So that's what I mean by sometimes it can be confusing as to actually who the beneficiaries are. And it's always nice when you get a will that defines this in great detail. So, okay, you've identified let's say a will, you've got an executor. If there's, you decided that there's no will, you've got an administrator and a petition is filed. The goal of the petition is to do two things basically. And that is to prove up the will, say, hey, this is it. This is what we've got, or to prove up that there's no will. And then to grant letters to the person in charge. They are called letters testamentary to an executor, and they are called letters of administration when there is no executor. So what these letters do, what this means by letters, give power to the executor or administrator to handle the estate. And again, all of this can be objected to. There's open court hearings to say that, hey, no, this person should not at all be in charge of this estate for whatever reason. But if there's no objection, the person named in the will, the executor, will handle the estate if they're willing and not able. Once the letters are granted, the executor administrator starts gathering up the assets. They start paying off debts. They manage property, and they ultimately pay out to beneficiaries. And all of this is done under court supervision. Letters can either be very liberal and give wide authority to the executor administrator, or they can be very restrictive so that each move by the executor has to come to the court and say, can I do this? Can I close this account? Can I sell this real estate? Can I move personal property out of the house? So each one of those requests by an executor administrator is normally noticed to all beneficiaries and interested parties. So if you are a beneficiary and you don't like what the executor is doing, then you have an opportunity to go in court and say, Your Honor, I don't want this house sold. I don't want this business closed down. I don't think we should close this bank account. Any number of things. So that's the beginning of the process. Getting an inventory, an idea of the assets. Keep in mind that through the process, you may discover more assets. Through the process, you may even discover more beneficiaries. But once the letters are issued, the executor administrator starts the process, and there will be hearings that all beneficiaries and interested parties can attend, and all of it is done under court supervision. So there you have it, the beginnings of the probate process. Just remember that this is intended for general information only. This is not specific legal, tax, or investment advice. If you need that kind of advice, you should hire your own advisor, including an attorney, an accountant, or a financial advisor. And I thank you very much for joining me. Please look forward. I'm going to continue this talk of the probate process and hopefully answer questions you may have. In the meantime, you can email me or you can leave comments below, and I'll try to get to them as soon as I can. Thanks, and we'll see you next time when we continue. Hey, I'm in probate. What's going on?